Hello, everyone. This is JJ Risha with Pismo Ventures, and I have with me Kari and Phil. Kari and Phil are with Buchalter Law Firm. It's a full-service law firm. I will let them tell you about the law firm and about themselves. But before we do that, let me just introduce our program for today. So we will be here for about an hour. And Phil and Kari are going in to go through a presentation. It's a case study in regards specifically to IP, patents, copyright, trademarks, etc. So after they're done with the presentation, we'll go into a Q&A where you can ask your questions. So, as soon as we start the Q&A, or if you have questions along the way, please don't hesitate to ask throughout the entire program. We encourage you to, again, engage with us, so that way this will be a more of a conversation between us. If there are any questions for Phil or Kari, you can always email them to me at pvinfo@pismoventures.com, and I will forward them to them accordingly. Just a little bit about Pismo Ventures. We've been doing these startup live events for the past few months. The most important thing we're doing here is we're trying to educate entrepreneurs and the ecosystem about what it takes to really be an entrepreneur and build a startup and build a successful startup. Learning about legal matters, learning about board of directors matters, learning about what it takes to really build and grow and sell your business. If you have not subscribed to our YouTube channel, please do so right now. You're right on it, so you can do that. And also, please follow us on social media, the ones you know. Before I let Kari and Phil start talking about their presentation, I just want to tell you a little bit about what Pismo Ventures is and what we do. So we are a unique combination of a venture firm and a venture accelerator, and we also have a software arm to help our portfolio companies. So we help businesses with their business needs. We invest resources and cash into our portfolio companies. We also develop software if they need it. We're agnostic, but if there's a need for software, we're able to do that. We facilitate funding, and we help open doors so that make sure that our portfolio companies are successful. And we are building a fund this year. Hopefully, with this COVID thing, interrupting our lives, hopefully by the end of the year, we'll have something in place. We are a value add hybrid cash and equity model. So we're startup friendly. We engage only on month-to-month basis, no long-term contracts, and we are a true business partner to our portfolio companies, and we are investors in our portfolio companies as well. So I'm going to let Kari first introduce herself and tell us maybe a little bit about Buchalter, and then maybe Phil will follow after her. Go ahead, Kari.
Thank you. Thank you very much. So as JJ said, we are a full-service law firm. We handle corporate intellectual property litigation, company formation, employment. We have a lot of specialty areas as well, including aviation and alcohol, and I don't even know all of them probably, but you name it, we probably have somebody that handles it somewhere. We have a good healthcare group as well. I handle intellectual property. I'm one of our shareholders in our IP group. I look a lot at patents. I handle trademarks and copyrights as well, trade secret policies, and across the board, whether it's procuring IP or licensing, transferring, general advice, portfolio management, enforcement, defense, across the board, IP, I can help you out. And as JGA mentioned, Phil will explain how we're going to do our presentation today, which might be a little bit different. But we do strongly encourage you in our live comments or private chat, whichever way you want to go. I'll be watching those. If you have questions along the way, we very much encourage you to put those in, and we will thread those into our discussion as we go through. So please feel free to comment or chat away, and we'll make this as interactive as possible. Phil?
Great. Yeah. Well, thanks everybody for joining today. And JJ, thanks for inviting us here. So I'm Phil Schroeder, obviously with Buchalter. I actually split my time between the corporate practice group and the intellectual property practice group. On the corporate side, I work with a lot of emerging companies up to lower middle market companies doing financing transactions and M&A. And the reason I'm also in the IP group is because I have actually an engineering background. I have a master's degree in mechanical engineering, worked for a lot of years in that world. So I tend to get brought into a lot of technology and intellectual property heavy companies and transactions. So with that, I do a lot of work with technology licensing, technology transfer agreements, and trademark work. And also a former chair of the IP group here at Buchalter. So with that, why don't we go ahead and dive in, and I'll give you a little sense for what we're doing today. This is intended to be an intellectual property counseling case study, and by that I mean that this is going to look, it's designed to be somewhat of a play or maybe a window into what it looks like, if you're an entrepreneur coming into the office, meeting with Kari and I, maybe for the first time, have some questions about your product and how to protect it from an IP standpoint. So Kari and I are going to be wearing a couple different hats in here. Hopefully that doesn't get too confusing, but for at the beginning, Kari will be kind of taking the role of the client and kind of asking questions, and I'll be answering a lot of the trademark type questions. And then about halfway through, we'll move over to the patent side, and I'll be taking more of the client role, and Kari will be taking more of the lawyer answering the patent questions. So, and as Kari mentioned, we'll be monitoring the questions on the side. So if you have some questions that are relevant, we can work them in the course of the dialogue here. So with that, I'll kind of turn it over to Kari as the client to kind of lay out what the hypothetical product is.
Okay. Thank you, Phil, for meeting me today. I'm really excited about a product that I've come up with, and I need advice on kind of getting through the next steps and what I should be doing. So, of course, everyone's talking about COVID right now, and thought it would be a good idea as people continue to go back to work, especially maybe in construction areas or those areas that people have to work in close or closer proximity, or could come closer to each other, or maybe even in schools. Who knows where the applications could be here. But if we mount a camera on a hat or a helmet or some other gear, it could be a harness, it might be a clip set on a coat or a shirt, something like that. And it receives the image that comes back, and through some software analytics or image detection and analytics, we can figure out a social distance and monitor whether social distancing is being employed and adhered to. We can send out an alert, whether it's an alarm that goes off if you're getting too close. There might be some, handheld interface to an app on your phone. It could go to a supervisor, or it could be like a real-time notice, just say, oh, you got to back up, give us some more space. We're thinking about calling it the COVID cam, and just kind of needs, somebody said it was probably about time as we start reaching out to developers and stuff like that, that we get advice from counsel. So we are here to try to figure out what we need to ask and where we go in our next steps.
Okay. Yeah. Well, that makes sense. So you're okay. So you're going out and you're reaching out to developers, software developers, and I guess also on the hardware side? Are you also looking for money at this point, trying to go out to investors to assist with the development?
Right. Once we build out the plan, we've got our developers and our software people already retained, and it was actually one of our software developers that kind of told us or asked whether we already started protecting this or where this was. And so we figured we needed to start asking that question. So we haven't started the development part yet. And after we talk to you, yeah, one of our goals or one of our options may be to reach out for investment and start marketing, start doing the consumer feedback assessment type stuff as well.
Yeah. Good. Well, I think you're right. I think it is the right time to start thinking about your IP protection as you're developing the product, and both beginning to talk to investors and beginning to and talking to your development team. And how you go about protecting that idea. Well, there's several different tools, and we'll go into details a little bit more about these. But it's good to have kind of a general understanding about what the different tools are and how they might apply to different parts of and different aspects of your project. Everybody thinks maybe patents as the thing that's always at the tip of their tongue, but there are other tools as well to protect different parts of the project. And I see my lights just went out because I'm sitting too still, so I'm gonna.
Do a dance for us. We didn't know that was coming. That's awesome.
So let me just go through that. So a little bit. So trademarks. You mentioned COVID CAM, and that's, I think, a potential trademark. A trademark, just for background purposes, is used to identify a source of goods or services. So that's what it is. It's a source identifier. It's a word, or it's a design, or a logo that when somebody sees that on a package or sees that on advertising, they're going to think of you as the provider of those goods and services. And you obtain those rights by using your mark, your trademark, with those goods and services in commerce. The second tool is patents, which you had already, hinting at. Patents protect inventions. There's somewhat of a high bar for obtaining a patent. The invention has to be new, it has to be novel and non-obvious. And if you're able to get a patent, then you'll have the exclusive right to use that invention, the exclusive right, to make, use, or sell that invention for a limited period of time. The government, by granting the registration, grants, a monopoly, if you will, over that invention for a limited period of time. Once that limited period of time is over, then other people can actually use that invention. Another tool for protecting your IP is copyrights. Unlike patents, copyrights do not protect ideas. That's kind of a major distinction between patents and copyrights. Copyrights protect the expression of an idea in some kind of tangible medium. So the definition is, the exclusive right for a limited period of time, although frankly a much longer period of time than patents, to copy, distribute, display, or perform publicly and prepare derivative works of an original work of authorship fixed in a tangible medium of expression. So that's a lot of words and kind of a mouthful. But again, it's about fixing an idea. Let's say an idea for a piece of art, an idea for a book, and then expressing that idea in some tangible medium. You have protection on the expression, but not the idea. As that relates to what you're doing with COVID CAM, you might look at the software, and software is potentially protectable if it is something that's novel and new and non-obvious. It could possibly obtain patent protection for that. Although patent protection on software has gotten, in the last several years, gotten a little bit more difficult, but perhaps getting a little more accessible now. But in any event, software could be protected as a copyright because your expression of that idea, your software code is the expression of that idea, and that would be protected by copyright. The last thing I want to touch on is trade secrets. You have you can decide upfront whether you want to use patents to protect your idea or copyrights, or you want to protect it by a trade secret. And trade secret is really just keeping it private. It's something that has economic value and has value because you're keeping it confidential and not discoverable by other people. And the other requirement is that you actually take steps to maintain the secrecy. Just real quickly, the main, or probably the best example of that, most known example, is the formula for Coke, which has been kept secret for over 100 years. And it's very valuable for that reason that they've been able to keep it secret.
Wow, that's a lot of information there. So I'm not sure that I'm going to retain all of that at once, but we are very excited about the name COVID Cam. So how about we start with that one of how would I protect that name COVID Cam?
Yeah, good question. Yeah, it is a lot of information. So we'll kind of break it down a little bit and dive into some of the details here. So for COVID Cam, that is essentially a trademark. That's going to be your identifier in the marketplace. When they see COVID Cam, they're going to hopefully think of you and your particular camera and your good, and understand that has, there's a certain level of quality that goes and reliability that goes with your product. So the first thing to think about is you don't necessarily need to file for trademark registration, for an application for trademark registration. There are common law rights for trademarks that you get by simply using that name in commerce. Common law rights have limitations, though. They're only regional in nature. So if you're just selling the COVID Cam locally in one particular region and not outside a particular region, you may have rights to that trademark in that geographic location, but not outside. So if there's someone selling the mark across the country, or selling a similar good with a similar trademark across the country, you wouldn't be able to stop it with a common law trademark. But you do have rights. And in some sense, if these days where people are selling through the internet, your geographic scope is a lot broader than it might have been, 20, 30 years ago, where it was a little harder to have such a broad reach. So you definitely want to maybe consider filing for federal registration of your trademark. And some of the real benefits of that are a presumption of nationwide use of the mark. So again, if you were just a local mom and pop shop selling on a street corner, your common law trademark might only be valuable for your particular community. But if you had a registered trademark with the U.S. Trademark Office, you could enforce those trademark rights across the country, nationwide. Another major benefit of filing a trademark application is that your trademark is going to appear on the U.S. Trademark Office websites when people do what's called a screen search. When people are trying to determine whether a mark might be available for registration, they'll typically search the Trademark Office website for any trademarks that are out there that might block their application. And if you appear in that search, that's usually a good deterrent and will ward away any potential infringers. They'll see your mark there. They'll know you're serious about protecting your trademark rights. And you may not even know this as the trademark owner, but there's going to be a lot of people who will see that and just back away and say, okay, that's already been used. Let me pick a different name. That's a major benefit. There are some other benefits where you can go to the U.S. Customs Service, register your name there, and they can potentially stop infringing goods that are coming in from overseas. Those are the major benefits of doing a trademark registration.
Well, that sounds really, really good. So do you think I can get a trademark on COVID Cam, or what's the actual step to getting the trademark on COVID Cam?
Yeah, so there's three things to think about when you're, getting ready to, either pick a trademark and protect a trademark. One is, is that something that the U.S. Trademark Office would actually allow to be registered? Second question is, if I use this trademark, is somebody out there going to sue me for infringement? And then the third question is, if you make the decision to go forward with that trademark, how good a trademark is this? How strong is it? So I think I'll start with the last question first about picking a good trademark that's going to provide you with the value that you want. And you see this, if you've got the screen there, you can see the different types of marks in terms of strength of marks. The strongest marks are those that are either fanciful or arbitrary. And by fanciful, I mean a trademark where you've simply made up a word. A great example of that is Google. I mean, before Google was Google and we all knew who they were, it was a word that was, not really in the English language. They just made it up. So any value that's attached to that word comes purely from the work that Google has done and the goods and services they provide. Similar to that are arbitrary trademarks. A great example of, and that's where you take a common word and apply it to a good and services that you just wouldn't think to do. A great example of that is Apple for computers. Everybody knows what an Apple is, but linking it to computers is a somewhat random link. Those are very strong marks. Now with COVID Cam, I think you've got something that is a little more suggestive. Obviously, you've got the word cam in there, which is similar to camera, and you've got the word COVID in there because you're using this as a means of stopping the spread of COVID-19. So, but you say COVID Cam, you don't know exactly what that is. There may be a question, though, as to whether that mark would be considered descriptive. And that's an important distinction, because if the Trademark Office determines that your mark is descriptive of the goods and services that are being provided, then you would not be eligible for trademark. You would not be able to get a registered trademark on the principal register for that mark. You could only get a registered mark on the principal register if you can actually show that you've developed something called secondary meaning. Secondary meaning is that, well, the primary meaning is it's descriptive of the goods and services. The secondary meaning is that people see those words COVID Cam, and they think specifically of you as the provider of those goods and services. That's the secondary meaning. So in order to get the trademark rights that you really want, you would have to at some point show that secondary meaning. There's different ways to do that, but it would be difficult to show, or really impossible to show at your point now, where you haven't even developed the product. The last thing, just to quickly mention, are generic trademarks, which are so descriptive of the goods and services that they're never eligible for or they're not even trademarks. They're not eligible for trademark protection or registration. A couple examples. The interesting examples of those are the ones that were actually very strong marks, but through lack of enforcement became generic. A couple examples are escalator, which was once a very strong mark, but is now used as a generic term. Zipper is another one, and yo-yo. Google needs to watch out for that if too many people start saying, I want to Google it when you say, I want to do an internet search. So anyway, that is the idea. I think you probably fit within the descriptive, or you're on the border between descriptive and suggestive. I think you're probably a little bit more on the suggestive side, so you can probably jump over that hurdle. The other thing we would want to do is do a clearance search, and I touched on this a little bit before. We'll want to check the Trademark Office website to see what similar marks are out there. Just real quickly before we walked into this meeting, I did a quick check to see how many other marks are out there with the word COVID in there. As you might imagine, that's kind of a hot topic right now. There's actually 323 marks on or applications out there right now that are using the word COVID in their name. So we'd want to do a closer search of that to see if anybody's using something like COVID Cam and anyone's using it for something that is similar to your proposed goods and services. The last thing.
So just because there's 300 marks out there that say COVID doesn't mean that I still possibly can't get. Yeah, so that's right. I can still possibly get a trademark on COVID Cam, even though other people have protection on COVID.
That's right. Most of those COVID marks are, COVID blank or, blank COVID, using it with something else, and they might be using it for wildly different goods and services. And that's interesting because when you're looking at the likelihood of confusion, which is basically the test for infringement of a trademark, when the trademark office does that search, they're going to look for marks that one, are similar in look and sound, and that are also similar in the goods and services that are provided. You generally have to check both of those boxes before the trademark office will block your trademark application. Similarly, the other third question I mentioned was, can I still get sued if I use this trademark? And it's interesting that the U.S. is what's called a first to use trademark jurisdiction versus a first to file trademark jurisdiction. Most other countries are first to file, which means that it's kind of a race to the trademark office. If you get to the trademark office first with your application, you will have prior rights over other people who come to the trademark office later. That's not necessarily the case in the US. In fact, you can actually have a registered trademark but still be sued by infringement from somebody who has common law rights, which we talked a little bit about before. If somebody has been using that trademark for a period of time prior to your use and prior to you filing a trademark application, they have prior rights to you and could actually potentially stop your use of the trademark, at least in their geographic region. Perhaps not nationally, but at least in their geographic scope. So I know I could talk more about trademarks here, but I know our time is short, so I want to make sure that we kind of get your questions answered on other areas too. So maybe at this point we can, if you have any questions about the trademarks, we can go forward on that, or maybe later. But I want to get to your questions about patents as well. So, and this is all
right. So yeah, let's talk about that then. So what about patenting the product, and how do I go about that?
Well, I'm going to turn that over to Kari, who's our expert on the patent sides. So, Kari, you want to jump in there?
Hey, how's it going? It's nice to join the conversation. And
okay. Well, first, I just want to say that what you did here is really, really cool. So you kind of went through the case study of someone coming into your office. You just saved somebody a few $100 just now.
Yeah, that's right.
But we are not giving specific legal advice. Let's put that caveat in there.
Yeah, exactly. But this is really cool because you really explained it well. At the same time, you're going through it step by step, and now someone would understand really what they should expect if they're doing a trademark or a patent and all that. So I just want to say it's really great. So go ahead. I'll let you switch around.
Yeah.
Yeah. So on the patent side, we have a couple of things to talk about, and thanks, Phil, for giving me some time to actually address this issue. Because you're talking about a COVID cam, you've mentioned a lot of different features to it. You have the hardware, you have the software analytics that's behind it, you have the code, which Phil touched on at the beginning, that can fall under the patent rubric, possibly, or the algorithm part of it probably can, versus the code itself falling under copyrights. So we need to kind of break this up. But first, I wanted to talk about, at least point out some of the distinctions between the patents and the trademarks. Even though all of this stuff falls under the IP, intellectual property umbrella, and they are typically handled by the federal government, the Patent and Trademark Office is actually called one name, although they have different branches. The Copyright Office is completely separate. The rules behind each one of these they overlap to some extent, but they are unique as well. So unlike trademarks, patents have no common law rights. That's a big distinction that we try to make at the very beginning. So as Phil said, you don't necessarily have to get the trademark registration at the very beginning, although we strongly advise it so that you get that national presumption of use. So as you enter the market and you enter in California, or you enter in whatever your original jurisdiction is, Arizona, what have you, if you have that federal registration, your use gets presumed across the entire nation. So somebody else can't pop up in Florida or somewhere else. And especially under the COVID response, these names are going to go very quickly. These solutions are going to come out very quickly. But you do have at least some flexibility. You're entering a risk zone, but there is some flexibility in choosing when you file for your trademark registration. That is not the case in the patent arena. So your patents, you have to make a cognitive choice at the beginning, whether this is going to be a trade secret, whether you're trying to protect it because you're going to maintain the secrecy, whether you're just going to allow it to be available to the public, or whether you're going to file for a patent application on it. So there are some differences between the United States and the rest of the world. As Phil said, on the trademark side, whether you're first to file or first to use jurisdiction, most of the world is first to file on the patent side. So if you make it to the patent office, you file your application, anything from the day before that filing acts as what we call prior art. That's going to be what we use to determine whether your invention is new and not obvious. So we want to cut off that as soon as possible. Again, especially in an area that's being innovated in so fast. There is a lot of focus on COVID-19. How do we get people back to work? So an invention like yours is going to have a lot of competition probably fairly quickly. So moving on the patent side is very important. In the United States, you are given kind of a reprieve, and it says for your own disclosures, if you put something out into the public, that disclosure isn't going to act as prior art against you for up to 1 year. But on the international, if you're going to go for protection outside of the United States, that statement from you can act as prior art against your own application. So again, a lot to think about. Whether you're going to start marketing, whether you're going to start doing your customer sales, your beta testing, any of that stuff can be seen as disclosures to the public and can be used against your own filing in some instances. So no common law rights, you need to go to the federal registration. So under the federal registration, it's an exclusive right, which I don't think came across at the very beginning when we were kind of giving you the summary of the different IP rights. It does not give you your own right to make and use and sell in the United States. It allows you to exclude others from making, using, and selling. So this is a way for you to put up boundaries against your competitors. So if you get a registration, then you can prevent your competitor from coming into your space. It's a mechanism that's very interesting for investors. And it helps you raise that money, because now you know that once you put your money into this idea, that a competitor can't say, oh, that's a great idea, I'm going to knock you off, and come in with different funding or better marketing or something like that and just overshadow you. So if you get that patent protection, that's a barrier to the other competitors from following behind you. It's also a very good mechanism because it's a description of what the invention is, what the idea is, and how to implement it, and then it becomes a tangible asset that can be moved around as an ownership. So typically inventions are owned by the inventor. You can have employment agreements, but those get a little convoluted sometimes about who actually invented it. Was it on employment time or was it outside of employment time, stuff like that. So if you have that patent application, you've described the invention, you've identified who contributed to it, and now you can assign it over to the company, and with much less dispute, or potential dispute, I guess, that you actually own this as a company and that somebody can invest in it and have that rights and that protection as well. And then there's other similar rights. It gets published after a period of time, so hopefully you can deter other infringers. You can use it at the border to prevent patent products that might infringe other CAM systems from coming into the U.S. jurisdiction, and you get to use specific courts and what have you. But so overall, federal registration is a good alternative for you to have available to you.
So you mentioned well, and Phil said there's a lot of trademarks out there with COVID. Are you guys getting feedback? I'm getting feedback for myself here. You mentioned that this might be very active. This might be a very active space.
Yeah, it's working right now. It looks like, yeah.
It's working. Okay, good. You mentioned this might be a very active space. Is there any way to tell if anybody has, invented something like this similar before, and if they'll actually be able to, register the patent?
So in your case, you're kind of in a unique environment. So yes, we can, just like in the trademark world, all the applications do get published, so we can see what other people have in queue, essentially. So we can search the patent office, unlike trademarks that publish almost immediately, if not immediately, depending on how fast their system is on any given day. The patents and applications are held confidential for 18 months. It's a year and a half. And in some instances, you can actually request the patent office not publish an application until it registers, till it issues as a patent. So there are a number of avenues that we would not be able to find something that might be filed before you. And as we kind of mentioned, or as everyone in the world knows, the COVID response is happening since December. So we're definitely within that 18-month window in this case. So anything specific to COVID response or detecting social distancing because of COVID, we won't be able to find. It just won't be published yet. We can still do a patentability search to see if there are other systems that predated COVID that might have other attributes, wearable camera systems, analytics for image processing that might at least inform some of the information of whether this is obvious or not. But as far as finding something that would be closer to what you're doing specifically in response to COVID, that one unfortunately will fall into the black box and we won't be able to see it. So it would be a balance of whether that search is worth it for you. And similar to the trademarks, you can ask the question of whether your product is patentable. And as I mentioned about what right your patent gives you, it does not give you the right to put something out on market. So another search that might be more beneficial than the patentability search might be your freedom to operate search. So again, you still have that 18-window black box of applications that we won't be able to see what's in the queue, but we would be able to see patents that might have predated or that are currently issued that can at least inform maybe some sort of image recognition system, calculation system, distancing. And as you're in development, if we find those now, then you can avoid incorporating those analytics or those algorithms into your camera system now and avoid that potential liability as you actually do put your camera out on market. So another thing to think about.
Great. Appreciate all the background there. So, I mean, I'm at a stage right now where, I'm trying to get the development done. I've got some expenses there. I'm trying to go out to investors, trying to get some money to assist with that. And I know, obviously, patent patents cost money. So I'm kind of wondering, what's the process for getting the patent, and is there, kind of a way to do that efficiently?
Yeah, so we, especially in your place where you haven't finalized a product yet, you don't have to have a final product to prepare a patent application. In some cases, it's good to at least start development, because then you will know a better detailed description of what product you're actually putting out on market, the details of the product that are actually unique to what you're doing that will be valuable to you. In your case, I can see you're taking a 2D image off of a camera system. So however you solve your specific problems of how do you get that distance determination, how are you giving real-time feedback to people in the field so that they can respond in an appropriate time to counteract the encroachment on the social distancing. All of those types of features, if you know those details now, we can put them into a patent application. If you don't, then you're walking this fine line of potential disclosures as you're going to go out and try to get funding on a concept where you don't have those details yet. So we got to remember at the end of our conversation, also talk about some of your other ways to get protection through non-disclosures agreements and other avenues. You use those in conjunction with your patent application. But we do have the option for doing what we call a provisional patent application. That allows us to detail out the invention, at least to the concept level, and you can get that area identified and secured. And that allows you, one, to keep your costs down, because you don't have, it never gets prosecuted by the patent office, and it allows you essentially to do a data dump or a description of your invention without any of the formalities of presentation. That allows you 12 months to convert it into its final form, into the utility application that actually gets looked at by the patent office and ultimately gives you the rights of exclusion that you're looking through the registration. Once you file for the utility application, you start a dialogue with an examiner, and that registration process, that dialogue, can take anywhere from 9 months to a year to upwards of 3 or 4 years, depending on what art unit you're in, or what technology area you're in. So they are options for expedited process, as we get to the utility application, because again, I think you fall under the provisional application. We can talk about some of those other areas for you. At that same 12 months of conversion for your provisional, you can decide whether you want international protection, and you file something called a PCT. It's the Pacific Cooperation Treaty. And a bunch of countries have come together and says, if you file this one application, then you can put off, it becomes a placeholder for going into a country that is part of the treaty. And it has covered pretty much all the countries that any of my clients have ever been interested in: Canada, Australia, China, Japan, Singapore, the European Union, Russia. Across the country, there's hundreds of countries that have joined. The only one that has come up that is not part of the European or the PCT application is Taiwan, and that is because Taiwan is not recognized as an independent sovereign. It's questionable whether it's under China or not. So if you want it Taiwan, then that one we have to keep special focus on. Other than that, you can do a PCT application. And then again, defer off for up to almost 3 years, 2.5, 3 years, which countries you want to select, which is a great thing for you to consider at your stage, because you don't know where you're going to sell. You don't know who your partners might be. You don't know where you're going to get investment. You don't know what your exit strategy is, who you're going to, end up selling to. So that gives you that placeholder to get that done. But overall, we're talking, 9 months to upwards of 3 years with that cost, being deferred over the whole process.
Great. Okay, good. So I think I've got
a lot of information.
Yeah, a lot of information for sure. So I think I've got a pretty decent understanding of the patents and trademarks, but you also mentioned early on about copyrights and trade secrets. Is there anything, how do those fit in? Do we need to do anything on that front?
So before we move on to copyrights and trade secrets, there was one other thing that I forgot to mention under the patents. It often gets overlooked, but there's actually another patent alternative called a design patent, and it covers the way something, the appearance, the look and feel, not the look and feel, the visual appearance, ornamentality of an object. So I'm thinking in your case where you're incorporating a camera into a hat or a harness or something like that, if you introduce an ornamental aspect to it, if the integration is aesthetically pleasing, you can get a design patent on that. That process is a lot easier than the utility application filing, and it will prevent others from at least knocking off the straight or a reproduction of whatever your harness hat system might be. And it is a good way to get a brand recognition and acknowledgement and protection in place very early on. So if you think of like the Coke bottle, the older Coke bottle that's all swirly in the bottle, Coke actually had a design patent on that bottle configuration. It was something that was recognizable on the shelf that their consumers could immediately go to and know that it was a Coke product. So it ties into the trademark side very well. But at least in your case, if you're integrating a camera into a helmet or a hat or some other harness, I'm thinking one of your obstacles is to make it comfortable and aesthetically pleasing so people will actually want to or will adhere to their responsibility to wear this thing. And if you can do that and it's something that's not clunky or something like that, then the design patent is something that we should also very much consider. But that again will happen after more of your development. You know what that final appearance or integration is going to look like. So, okay, sorry about that digression. Let's go over to the copyrights and then
that was helpful. That's good.
Trade secrets. All right, sorry about that. So the copyright, as Phil mentioned at the very beginning, in your case, it's likely to cover the code of what you're doing. We can cover the code through the patents, and the difference between the two is going to be copyright is going to protect more specifically in the coding itself. So it will protect you against one of your developers or your coder or one of your employees from walking out the door with your code, commandeering your code,
right?
And using it if they're looking at their code. There has to be, for a copyright infringement, some sort of copying of the copyrighted product. So they need some sort of access to that code. But it does help if somebody gets access to that code in some way. It's an easy registration to get, and it's again, it's an easier avenue to protect somebody just straight walking out the door with your code. On the patent side, where you get protection, it's related to your code because it's the algorithms that your code actually employs, but it's going to be more the functionality part. So it's not a specific coding structure. It's not a specific call set or anything like that. It's going to be the functionality of receiving an image through the camera, analyzing the image in whichever way you've chosen in detecting some sort of distance, whether you end up having two cameras so that you can triangulate a distance, or if you somehow stick known recognized objects in your image field so that you get some sort of sizing scale. However you end up solving that, those features come in. And that is how we end up protecting the algorithm or the functionality through the patent. So those are the two scopes of what you get. Both are beneficial, and both give you different scopes of protection, and they protect against different violations of your rights, so to speak. Let's see. So for the trade secrets, some of the other things for your copyright may also include some of your brochures and stuff like that, but it's definitely something we'd probably consider further down the line, not so much at the stage you're in. So we'll park the rest of that conversation, but do think about copywriting your code. That copyright would happen after your code is complete and ready to go, and you want to copyright your code. The preference is to copyright within 2 months of publication. So the 2 months when you first disseminate it out, then you can actually backdate your protection as if it occurred as soon as it came out. So you have that 2-month window from when you first publish on the copyright side. Trade secrets are available, as Phil said, if you can keep the things secret. And in your case, if your software is residing on the helmet, there's a lot of programs that decompile and can get access to software. So if you're actually giving out your software to someone, disclosing it in any way, of course, you're not gonna be able to keep it secret. If you are communicating like over the cloud or an internet and you're able to retain your code, and somebody can't reverse engineer based on the inputs and outputs of what your code is doing, then you might have some trade secret alternatives. I will say it's very hard to keep trade secrets at the stage that you're in if you're looking for substantial outside investments, because all of those investors want to look under your skirt and see what's going on, or the hood, or whatever your analogy is that you want to use, to figure out what's going on. And eventually you typically have to disclose that at some time. And therefore your patent avenue is likely going to be a stronger or a better avenue if you're going to be looking for investment in any way, or if you're going to bring in other people like developers, or one developer is going to talk to your manufacturer, or any of those things. The more times you have to share whatever it is you're trying to keep secret, the less likely you're going to be able to keep it secret. Phil, you want to look at your comments there, or client?
Do we have any?
I got a comment.
Oh, you did. Okay. I'm not. Maybe I'm on the wrong screen here, so I'm not seeing it.
Okay. Well, I will ask myself as the client. Did you get it?
There. I see it there. Yeah. Okay. This is a question that came in. When should a patent be assigned to a startup in order to gain investments? Must the assignment always be stated on the patent? What if the startup isn't an entity yet?
Very good question. So in any of these, you can't own something if you don't exist yet. So you're not going to be able to get an assignment if you haven't started the company. So it's good that you're talking to Phil and I, because Phil will, as the corporate guy, can help you set up that company. And we typically advise starting the company, especially if you're already interacting with developers and stuff like that. You want to shield yourself from the personal liability, and that's the whole point of having that company created. So create that company so that you can start that protection against you, and then we can assign over to the company. As far as how it interplays with investors, it's going to be how savvy is your investor. If you have an investor that knows what they're doing, they're going to ask for that assignment because they're going to want that collateral. They're investing into a company, and
that's the first thing I ask for. So.
There you go. But if it's a friends and family thing, you're usually not going to get that answer or that question. So talking to you as the company, I would advise, depending on who's in your company. I mean, it's always the fact specific. If it's you by yourself, then keep the invention to you as long as possible. Because then you are retaining more ownership and ability to control that asset. And if the company does go down, the asset's yours. You can license to your company and then retain it as a second chance if your company fails. Most investors are not going to put up with that. They're going to say, I'm putting my money in, so I want as collateral, as an asset against that money that I'm putting in, to be in the company itself. But again, it depends. Once you get that ask, then you can do the assignment. We can do assignments as part of closing docs in investment rounds and stuff like that. So you can keep it in your own name until that last minute when you get that investment. But it's going to be fact specific on who your investors are and what your company looks like. If your company is made up of more than one or two people, or more than a single person, then you might want that assignment into the company to hedge against a dissolution or a disagreement between the individuals. Or especially in your case, if your inventors are coming from outside of the company, you're going to developers that might end up contributing to part of the invention, then you want that assignment early on.
That's I could tell you for a fact that's first thing we ask for when we're investing. When you're putting money in, it has to be assigned. So yeah, a lot of times we see these patents not, they're still personal, but they're not assigned to the company, but they'd have to be. So, all right, are you done, Phil, with case study?
Yeah, I think we're done. We didn't leave a lot of time for questions, but yeah, we're done. We could go on, but we're done.
No, we can go over a little bit, yeah, if everyone's still okay with that.
Yeah, there's one other point that I did want to bring up because I had mentioned it in my part. So as client now, I just want to circle back with you guys as attorneys. You also mentioned other ways that I can protect my invention. Can you go over those really quickly? Phil.
Other ways to protect the invention. Yeah, you mean in terms of, well, yeah. So we talked a little bit about the copyrights and trade secrets, but from, a contractual basis, and we touched a little bit about touched on this when we talked about the assignment question as well. You definitely want to make sure that all of your vendors and all of your employees, consultants are assigning all of their IP rights to the company, because you want to make sure that all the IP and all the ownership of the IP is collected with the company. That's just, that's really important. And I see this often with M&A deals come up, and you say, oh, this software developer, or maybe this founder even, never assigned his rights to the company. So you definitely want to make sure that you cover all those bases with all of your vendors, especially anybody who's touching the hardware or software development. And then in terms of your hardware and your manufacturing partner, make sure you've got the flexibility. If they're doing design drawings or developing processes or anything like that, make sure that you own that, or at a minimum have the right to take that and use that with other manufacturers if you need to. You might be starting off with a smaller manufacturer who can only do a small run, and if you're going to grow, you're going to need flexibility for that kind of stuff as well.
Well, this is interesting because I see it all the times, just like you, and it's the easiest time to do it is at the very beginning when everybody's really excited, and they'll sign anything.
That's right.
To some extent.
Once there's a deal on the table and there's money on the table, it's amazing how difficult the negotiation becomes.
Yeah. So just like sign here, they'll sign blindly initially, but
right, yeah. Right.
So I have a couple of questions, and I think they're really, they came from what you guys talked about. One is, because of this, you talked about the foreign, patents, and so how did the Brexit impact the foreign patent and trademark applications worldwide, I guess?
I can answer from the trademark perspective. So at this point, there's kind of a cutoff at this point of December 31st, 2020. And basically where you are at that point is going to decide what's going to happen. If you have a registered trademark with the European Union used to include the UK. If you have a registered trademark on December 31, you will automatically be given a registered trademark, a registered UK trademark. So you'll end up with essentially two registered marks, one with the UK, one with the rest of the European Union. If you're still in the application phase at that point, you haven't registered yet, your European Union application will continue on, and you'll have the opportunity to then file a UK application specifically for the UK, and you'll get the benefit of your priority date back to your European Union filing date. So you'll get that benefit, but you are going to have to file a separate application.
Interesting. Okay.
And quickly on the patent side, there's actually little change on the patent side. The patent office, the patent office in Europe has always had extension states that were outside of the EU. So the UK just became one of those extension member states. So you can go into the UK separately, as you've always been able to individually choose your countries in Europe, or under the entire umbrella of Europe, the UK is still included.
That's just like completely confusing. Like the trademarks is not, but the patent is just like why? Okay, maybe it's for attorneys to make more money.
Yeah, exactly.
So I've heard this before. People, usually ask this, but I don't know. I never know how to answer it. But how does the Amazon brand registry work? Either one of you know about that?
Yeah, I can. Kari, you can jump in here, well, because I know you've had some experience with it. But yeah, Amazon is provided this service, the Amazon brand registry, where you can basically notify them of your registered trademark, and it does need to be a registered trademark. Application phase marks don't get the same benefit, but if you have a registered trademark, you can use some of their tools to help find infringing products that are being sold through Amazon. And Kari, I think you might have some experience with the takedown procedures in Amazon as well, but I think there's some streamlined takedown procedures if you do find some infringement.
Yeah, but essentially it's just a mechanism that I have a client right now that's having a lot of difficulty. They do backyard toys and games and stuff, so they are selling out with everyone having their kids at home, and every time they have out of stock notices, they're getting 10 or 15 other companies coming in that are coming in with something similar to fill that gap, and using the takedown method or mechanisms to keep them out of the way is the way to go.
Okay, all right. Usually when it comes to trademarks, how is there like a deadline or an expiration on that, or does it last forever? How does that work?
Yeah, so once you get the trademark registration, it has a 10-year life. So between the 9th and 10th year, you have to file an affidavit and demonstrate that you're continuing to use the trademark and that you have been using the trademark all that time. And if you do that, then you can renew the registration for another 10 years, and you do that every 10 years. Now, there's one caveat to that. In that first period between the 5th and 6th year, there's actually an additional affidavit that you need to file. Between the 5th and 6th year, you need to, again, confirm that you're using the trademark, demonstrate your use of the trademark. And it also, at that same time, you have an opportunity to file a request to make the mark, quote unquote, incontestable. So at the same time, you're filing the required affidavit to show, yes, I am using it, I want to continue my rights. You file the affidavit to make it incontestable, which kind of gives you additional trademark rights. The mark can still be canceled in certain ways, but it does limit the number of ways that some third party can come in and try to cancel the registration.
So even if you don't renew it on between the 9th and 10th year?
If you don't renew it between the 9th and 10th year, the registration will terminate, and you'll kind of default back to common law trademark rights at that point.
I see. Okay. All right. Kari, what about patents? Do they expire?
Yeah, so your patent term is typically 20 years from your date of first filing. and you do not have a way to extend them. You do get some extension days if the patent office is slow in registering, but the benchmark is 20 years from the date of first filing. And the difference is you're giving a disclosure for an amount of monopoly time granted by the government. So they're not going to grant that unlimited monopoly to you.
That's interesting. So this is why I guess sometimes you see new drugs coming into the market, and because the previous patent on a drug just expired.
Absolutely. Yep.
And then you have now,
That's when the generics come.
Yeah. So that's the I guess the generics, right? So
yep.
All right. Couple more questions.
We have a question that came up.
Oh, we do? Okay, let's do that.
What's the difference between a registered trademark and an ordinary trademark? Company name, product name. Phil, that's to you.
Yeah. So, ordinary trademark, I'm not exactly sure what you're referring to. That's probably referring to a common law trademark. I don't think there's a specific designation for an ordinary trademark. The registered trademark becomes registered when the application is approved, and then it becomes a quote unquote registered trademark. Before that, you have the common law rights, which I mentioned, which are regional in nature. And it's another nice thing about having a registered trademark is that when you go in to enforce your trademark, well, two things. One, if you're enforcing it, just with a cease and desist letter, people will take you a lot more seriously if you can show them the registration. And two, if you have to get to a court of law, you have a lot of presumptions about your use, which you don't have to go through the trouble of proving with a common law trademark. A company name doesn't necessarily give you rights in trademark rights. I mean, if you're using it, well, it does and it doesn't. It could give you common law rights, I suppose. If your company name is on your packaging, then people might start to associate with your company name with the good, but then it's really sort of, it gets a little fuzzy, I guess, because then it's really operating like a trademark, because again, it's the designation of the source of the goods and services. A product name is essentially a trademark. If you haven't registered it, then maybe a common law trademark at that point.
Yeah, so I would just clarify, both of them are trademarks and they both cover the same thing. It is whatever the name is, the logo, the sound, the visual, that customers identify a source or use to identify the source of the goods. The registered trademark just means you filed the application at the federal level United States Patent and Trademark Office. They did their search and said nobody else is close to this, that it's not descriptive, and that you get a federal registration and you get a nice ribbon copy. They don't have a ribbon on it anymore, but it used to be a nice ribbon copy that says you have this registration. And then, like Phil said, the distinction between the two, they both protect the same thing. They both overlap. So if you have a federal registration, you have common law rights, or an ordinary trademark as well. It's just your federal registration gets you the plus sign. It gets you more rights on top of that.
I like the ribbon. I don't know why they removed the ribbon.
Always lost. I like the ribbon too.
It just makes it different, right? So, all right. So, do you? Just a couple of questions, maybe. One is on the trademark infringement. What is the test for trademark infringement? And then maybe, Kari, you can talk about the patent infringement.
Yeah. So, we touched on this just slightly earlier. The test for trademark infringement is likelihood of confusion. And what that means is it's likelihood of confusion in the marketplace with the potential consumers of your product or service. Is that potential consumer, when they see your trademark, are they going to be confused into thinking that that is manufactured or provided by some other manufacturer or provider. That's really the issue. Is there confusion for the marketplace? And it's a many factor test that goes into that. I mentioned a couple of factors earlier, which are the dominant ones that have come up most often are the look of the mark, the sound of the mark. Sound is relevant in terms of pronunciation because you can advertise on the radio where you don't actually see the word. Okay. So you always have to keep that in mind. A lot of times people think, oh, what if I just change the spelling? I said, that doesn't really cut it because the sound is still the same. So, that impression is important. And then obviously the goods and services that you're using the mark with are highly relevant because you can have the exact same word used for two completely different products and you don't necessarily have infringement. The exception to that are highly famous marks. Where you end up, having a broader scope of protection. You can't use Google for clothing. Maybe I don't know if they have any clothing. Maybe they do. But make up a product that you typically wouldn't see Google with. You probably still can't do it, even if Google is not providing that product. Just because their mark is so famous that people are just going to assume that you're associated. So very famous marks have a broader scope of protection.
Very interesting. Yeah.
Other important factors are the channels of trade, where the goods and services are being sold, how the consumers interact with them. If they buy those goods and services in radically different places or different ways, then there's less likely to be confusion. How the consumer buys those products and services. Is it an impulse buy where they're not doing a lot of thought? Or is it, a software program that a company is going to do 6 months of due diligence before they buy the product? If you have a lot of due diligence involved, then there's less likely to be confusion. Other things that are important are the number and nature of similar marks out there in the marketplace. Is this a quote unquote crowded field where you have a lot of similar marks providing similar products and you're just kind of, your trademark is just sort of wedged in between a lot of other similar marks? If that's the case, then your mark, is going to have a smaller scope of protection. Those are a flavor for some of the most important factors, but it is a complicated test with a lot of different factors involved.
So the patent side is much easier. I can answer this one much faster. At the very end of the patent, you have something called a claim where it just itemizes. It's almost like a bullet point list. My invention has element A, element B, element C. And if you have element A, element B, element C, then you have infringement.
That's it.
Yep.
That's pretty easy. All right. So I think, we've gone over a little bit here, about 10, 15 minutes maybe. So first, I want to thank you very much for being here today. I'm going to do a little some closing, but meanwhile, I want you to think about maybe one advice on trademark and on patents that you could provide the listeners. What would be just one advice if the listeners were to, come out with, you gave them a lot of information, but if they were to come out with one at the end, what would that be? So meanwhile, I'm just going to do some closing. So first, I want to thank everybody for coming in today and joining us. I really appreciate Kari and Phil's input today. That was very, very valuable. I learned a lot of stuff, and I thought I knew most of it. So I learned quite a bit. Again, if you have not subscribed to our YouTube channel, please so. Also on social media, please subscribe as well. We have a lot of we're booked for for these live streams through the end of September. So we have a lot of things coming up. Next week is Scott Hamilton. The week after that is Steve Mednick. The week after that is Bruce Verga. Week after that is an angel group led by Zandra. And so a lot of people that you will want to listen to. So it's really great, a great lineup that we have coming up. Let's see if there's anything else. I think that's it. So Kari, what would your one advice be?
Talk to an attorney early. because the patents have disclosure limitations, even if you're not developed yet, at least talk to someone, figure out what your timing is, what you want to say or don't want to say to other people, and how best to not say things that you're not supposed to be saying.
There you go. That's good. Phil?
Yeah. So I would say don't get too, married and committed to a trademark without having done your clearance search. A lot of times I'll have clients come in and say, they just came up with an idea for
awesome
a mark.
though, Phil.
What's that?
COVID Cam is awesome.
It is awesome.
Not moving away from it.
Discourage it. But until you do the search, don't get too wedded to it, because a lot of times I'll have people who just, they've been thinking of this idea for a trademark or a brand forever, and they just love it. And then you get in there and you do a search and you say, oh, look, there's there's 5 or 10 marks that are kind of doing something similar right now. And I mentioned something about a crowded field earlier. If that's the case, and you've got a mark that you're trying to wedge in between a bunch of other similar marks, there's sort of 2 issues with that. One, it's probably going to cause you problems. You might have trouble getting it through the trademark office, and that's going to that's going to be more expensive. If you have to go through a couple of rounds of arguments with the trademark office trying to get it past them. You also may end up with cease and desist letters down the road, which is going to be expensive to deal with. And then the last thing is, even if you're able to clear those hurdles and get a registered trademark, it's not going to be as valuable, because you're going to be in that crowded field. And unless somebody's really infringing your exact mark, you may not have a lot of leeway and broad scope of protection. So it's going to cost you more, and it's going to be less valuable.
Very interesting. So first, I want to mention that this YouTube and this recording will be available on YouTube and other media channels by tomorrow morning. If you want to review it again, you can. Phil and Kari, did you want to give out your email addresses? Is that something you want to do, or you can? You don't have to, but if you want to, you can, and so people can reach out to you. So you could type it in the chat box. That would help. Okay. Otherwise, I want to thank you very much for being part of this live stream and being so valuable, providing valuable information to the entrepreneur and startup community. And I truly appreciate your time. Thanks, Kari, and thank you, Phil.
Thank you, JJ.
Yeah, thanks for having us, JJ.
No problem. All right, we'll wait for your emails to show up, and then we'll go from there. All right, have a great day. We'll talk soon.
Thank you.
Bye-bye.